Energy infrastructure projects now face an average delay of 7 years due to litigation. Developers allocate up to 30% of initial capital to legal defense before breaking ground. Opposition to energy projects has evolved into a professionalized legal industry. Local groups utilize environmental review processes as tactical weapons to create indefinite financial strain on developers. Local zoning ordinances often lack the technical flexibility required for modern energy assets. This regulatory gap allows small municipal boards to block projects of national economic significance. State-level preemption laws strip local councils of veto power over designated energy corridors. This shifts the decision-making authority to specialized state commissions with broader economic perspectives. Siting boards provide a unified permit process that overrides fragmented local approvals. By consolidating environmental and technical reviews, these boards reduce the total number of litigation entry points. Section 216 of the Federal Power Act grants the government backstop authority for transmission lines. This allows for federal intervention if state processes fail to resolve siting within 1 year.
The latest reforms to the National Environmental Policy Act impose strict page limits and 2-year deadlines for environmental impact statements. This limits the scope for procedural lawsuits based on document length. Legislative mandates now require courts to expedite cases involving clean energy infrastructure. These laws set strict statutes of limitations, often as short as 60 days, for filing any environmental challenges. Courts are increasingly applying stricter standing requirements for plaintiffs. To sue, an individual must prove direct and tangible harm, rather than just general opposition to the aesthetic impact of technology. Strategic legislation prevents the automatic suspension of permits during a lawsuit. This allows construction to proceed while the case is pending, provided the developer assumes the financial risk of reversal. Community benefit agreements function as legally binding contracts between developers and local stakeholders. By securing local support through financial investment, developers effectively neutralize potential litigants before they file. Anti-strategic lawsuit against public participation laws protect developers from meritless litigation intended solely to cause delay. These statutes allow for the rapid dismissal of suits and the recovery of legal fees.
The legal definition of public use in eminent domain cases is expanding to include carbon capture pipelines and high-voltage transmission. This facilitates the acquisition of essential easements over the objections of minority landowners. The Dormant Commerce Clause prevents states from discriminating against out-of-state energy producers. This prevents local regulators from favoring legacy fossil fuel assets over new competitive renewable energy transmission projects. Permit-by-rule systems replace individual reviews with a standardized checklist of environmental criteria. If a project meets all predetermined technical standards, the permit is granted automatically, without public hearings. New legislative proposals require plaintiffs to post a significant financial bond when seeking a preliminary injunction. This bond covers the developer's costs if the lawsuit is ultimately found to be without merit. While broad agency deference has faced judicial rollback, specific legislative language can still empower technical agencies to make final determinations. Precise statutory drafting is now more vital than ever for project stability. Strategic use of severability clauses in project approvals ensures that if one part of a permit is struck down in court, the rest of the project remains legally valid and can proceed.
Opponents often claim that developers are illegally splitting one large project into smaller ones to avoid intense environmental scrutiny. Legal teams must demonstrate a single, comprehensive plan to survive this procedural challenge. Categorical exclusions allow projects with minimal impact to bypass full environmental assessments. Expanding the list of technologies that qualify, such as geothermal or battery storage, significantly accelerates the deployment timeline. Regulatory arbitrage occurs when local governments pass new laws specifically to block a pending project. Vested rights doctrines can protect developers from these retroactive changes once significant investment has been made. Including mandatory arbitration clauses in land use agreements and community contracts can keep disputes out of public courtrooms. This private resolution process is typically faster and less susceptible to political influence. To defeat a preliminary injunction, developers must prove that the public interest in clean energy outweighs the local interest in maintaining the status quo. Quantifying carbon reduction and grid reliability is essential. Federal grants for grid modernization often come with requirements for states to streamline their permitting processes. States that fail to reform may lose access to billions in infrastructure funding. Developing on brownfields or former industrial sites offers a path of lower legal resistance. These sites already possess the industrial zoning and infrastructure needed, making them less vulnerable to environmental obstruction. Outsourcing permit reviews to pre-approved third-party engineering firms can eliminate administrative bottlenecks. This ensures that the review process is driven by technical data rather than understaffed municipal offices. Maintaining a flawless administrative record is the best defense against a lawsuit. Every public comment must be addressed, and every technical decision backed by data to withstand a later judicial challenge. Early and transparent engagement with local leaders can identify legal flashpoints before they become lawsuits. Securing early political buy-in often results in local ordinances that favor the project rather than hindering it. Negotiated rulemaking involves all stakeholders in the drafting of project-specific regulations. This collaborative legal approach reduces the likelihood of future litigation by addressing concerns during the legislative phase. In certain jurisdictions, mineral and subsurface rights take precedence over surface ownership. This can be a decisive legal factor for geothermal or hydrogen storage projects that require access to deep geological formations.
Using compensatory mitigation banks allows developers to offset environmental impacts by purchasing credits from established restoration projects. This provides a legally certain pathway to satisfy environmental requirements without on-site delays. Several states are establishing specialized energy courts with judges who possess deep technical expertise. These courts provide more predictable and faster rulings than general jurisdiction courts on complex engineering issues. New insurance products now cover the costs of litigation and project delays. This transfers the financial risk of not-in-my-backyard opposition away from the developer and toward the global insurance market. Artificial intelligence is now used to analyze thousands of past legal cases to predict which aspects of a project will face the most opposition. This allows developers to proactively adjust their legal strategy. Federal Energy Regulatory Commission orders are standardizing the interconnection process. This prevents local utilities from using technical studies as a legal pretext to delay new competitors from joining the grid. Merchant transmission developers can often seek public utility status. This classification provides access to eminent domain and state-level siting protections that are typically reserved for traditional monopolies.
Opponents often sue by claiming a project fails to account for the cumulative impact of other nearby developments. Modern legal strategy involves using high-resolution data to prove that impacts remain within regulatory limits. Repowering existing energy sites with newer technology often benefits from grandfathered legal rights. Using the existing footprint and permits can bypass the entire initial siting and zoning battle. International developers can leverage investment treaties to challenge discriminatory local regulations. These treaties provide a separate legal forum outside of local courts to protect foreign capital from political interference. In cases of extreme local deadlock, a state legislature can pass a specific law designating a project as a matter of urgent public necessity. This provides the highest level of legal immunity from municipal interference. Addressing environmental justice concerns early creates a legally robust defense against civil rights claims. Incorporating equity into the project design prevents one of the most common modern legal challenges to infrastructure. Following the legal hierarchy of avoid, minimize, and compensate is vital, demonstrating that all efforts were made to avoid environmental impact before proposing offsets makes a permit nearly impossible to overturn in court.
Structuring projects to provide direct tax revenue to local schools and services creates a legal constituency that opposes litigation. When the community benefits financially, the political will for a legal battle vanishes. Developers should push for summary judgment as early as possible to resolve cases on purely legal grounds. This avoids the cost and delay of a full trial by focusing on the adequacy of the administrative record. The combination of state preemption, specialized courts, and federal backstop authority is creating a new era of permitting certainty. Projects that integrate these legal strategies from day one will lead the energy transition.